What he is alleging quite clearly is that there is systematic fraud on behalf of Britain's largest bank, effectively feathering their own nest to bring down businesses that without the intervention of the bank would have survived and thrived.
Businesses in distress is one thing, but businesses being driven into distress is something completely different.
Or has the bank deliberately attempted to engineer a situation in which the business defaults or in which the business actually breaches their banking covenants? That is a key claim made within the Tomlinson reports, that often businesses found themselves in difficulties due to deliberate efforts from the bank to ensure that they did find themselves in difficulties. This would relate to revaluations and so forth. And once their banking covenants were breached, then the business was placed in the so-called supporting hands of GRG.
Mr Kelly, you were talking about when businesses get into trouble, they have conversations which aren't particularly pleasant with their financiers. The allegations here are that the trouble that the businesses have got themselves into are solely arising out of the bank acting on the terms of the agreement with businesses that were otherwise not in trouble.
Summarised by the fact that banks and their customers have had trust in banks over so many years, and that's been brought up through the generations. People think they should trust their banks, but there's a complete imbalance in that relationship. And what's grown up is a practice of a very commercially minded organisation managing personal and business money, which creates such an imbalance where people are not qualified to understand what it is they're being offered by their so-called friends, the business or relationship manager and their bank.
A lot of things people say about banks, are they this, are they that? They trust us, they give us all their information, and I think that puts us in very good stead.
Once businesses are subjected to the support structure of GRG or global restructuring, what is the nature of that support? Is it really an effort to get a business back on track? Or is it the case that businesses, once in the hands of GRG, are subjected to unfair and penal rates of interest, are subjected to unfair and penal charges?
You pay your interest, we'll charge you $200,000 fee, so if anything goes wrong, you can't tell anyone. And guess what? If you trip over the line, your interest rate's 18%.
And more concerning, are often asked to pay for reports and valuations which are almost never in the interest of the business themselves. The number of cases I have seen of valuations which have changed dramatically because the valuations have been instructed, or the valuers have been instructed to undertake a second valuation by the bank, does raise significant concerns as to the independence of those valuations.
So just 9 months after the valuation, the reduced valuation, Bankwest advised us again that they needed another valuation at our cost, being $9,500. Sorry, it was 5 months later, just 5 months later, another valuation at our cost. The new valuation came in at 22% less than the valuation of just 5 months before.
They had a large portfolio of flats. One of the flats in question had been valued by GRG at £100,000. They achieved a sale price of £145,000 yesterday. So in other words, the valuation was 100, the sale price achieved yesterday was 145,000, and yet the bank were still unwilling to give any compromise in relation to the valuation of the entire portfolio.
In February 2011, we got a purchase offer for the Lighthouse Beach Resort at $14 million, being 22% higher than what the valuation was. So in other words, we got an offer for it close to what the original valuation was, but almost proved them wrong.
In this situation, they had a hotel which was valued independently by Matthews and Goodman at £3.4 million. The bank were clearly unhappy with this valuation because this valuation gave them a very healthy loan-to-value position. So the bank instructed the business in question to have a second valuation conducted within 2 months. They charged the business £3,500 for the privilege. The second valuation came back as £1.65 million. Net result of that was clearly the business was now in breach of their banking covenants. Now, it is not surprising that businesses feel hard done by when they can have a valuation conducted independently, highlighting a value of £3.4 million, and less than 3 months later, another valuation at this point in time, instructed by the bank, paid for by the business, comes back with a valuation which is less than half of the original.
Does he agree that very often it's the time scale that the bank demands a response that kills a business completely? The business in my constituency was given 24 hours to resolve a position. There wasn't a difficulty. Bankrupted the business, and now the principal has gone to work in the Far East, producing lots of jobs and lots of really good business in the Far East, taking it away from Mid Wales.
We were left hanging for 9 months, all the while being told our development was fine, and then in 2009 we were given 24 hours to pay back $6.4 million.
Time and again, what I have seen is when businesses go into GRG, the fees charged by the bank go up, with apparently no relation to the amount of work being given by the bank in support of the business in question. Independent reviews, so-called independent reviews, are forced upon the business by the bank. This could be evaluation, this could be accountancy work, this could be solicitors. Time and again, these professional fees are charged to the business, but the instructions come from the bank, and quite often the reports go to the bank first. I had a constituent, as I mentioned, who was struck with a £4,000 weekly fee for the continuation of his banking facilities. After 3 months of negotiation, GRG agreed that they would do it for £2,000 per week. There was no explanation as to why initially it was 4,000, why now 2,000 was acceptable. I get the impression that the reason that it was 4,000 initially was because there was a feeling that he could get away with 4,000 a week. And subsequently it was 2,000 because the business put up a fight, their accountants, their solicitors argued the case, and so did their MP.
On the 10th of August that year, just a few weeks after the valuation was given to us, Bankwest advised us our interest rate margins would double. Bankwest then advised us our interest rates would double again. Our profits were at record levels, but I said we just could not afford to pay the 18% interest rate.
Just to highlight an interview which took place between Derek Sach, who is the founder of GRG, and 12. That's a rather chilling interview if you are of the view that the bank should be there to support small businesses, because it describes the steady flow of distressed businesses into GRG as an opportunity. Now, this is a key point, I would argue. If the head of GRG is of the view that distressed businesses coming into his organisation are opportunities, then I think we have a view of the world which is not there to support businesses. It's there to try and gain commercial advantage on the back of those individual businesses. And if there's any MP here today, any member here today, who have a business involved in shipping, then you should be very concerned, because Mr. Sach also highlights the fact that he sees significant opportunities in shipping, because shipping is currently going through a difficult period. In other words, the vultures are hovering within GRG, waiting for a further supply of distressed businesses to be taken advantage of.
And this sort of engineering of loan defaults, which allows them to put the company into GRG. So not only are they taking huge amounts of fees from these companies that bank with them, but they are then also asset stripping them and making sure that those businesses can no longer exist properly.
About that business that went down. It went down owing £1.2 million, of which £900,000 was bank charge.
9.5 months of doing what I used to do, they charged us $1,055,000. As I said, I was paying myself $87,000 a year.
Where RBS, using Global Restructuring Group, actually started to take the money out of bank accounts that were expressly set up by business to pay HMRC. So they weren't just taking taxpayer money to exist themselves. They were actually taking that money that was supposed to be going to the Treasury in accounts that were specifically set up to pay HMRC.
It is not complex. You sold the property for $9 million. You received $9.9 million. You didn't want to give up the $0.9 million, the $900,000 to the tax office, and it's gone on for years until finally an independent expert has made a judgment. And what I'm saying to you is this. I believe the receivers have done this right through your network of selling these places up, these commercial properties. And I believe you're hanging on to a lot of GST component in those sales. We need to be assured and see that this loophole, if you want to call it, is patched right over.
Senator, that's obviously one we will certainly look into. It's not obviously widespread.
But can we really say that individuals have access to justice when RBS as a company has access to some of the best legal minds in the country to support them against what are tiny little businesses? I mean, I would say that is not access to justice.
Shortly after that, we got a letter from the Financial Ombudsman Service. The conclusion is they're unable to progress or reconsider our matter because it's under receivership and they have not received the authority of the receivers. So in other words, they need the authority of Taylor Woodings, who have robbed us, to investigate.
Because if MPs are not surprised by allegations of behaviour which is verging, in my view, on the criminal, I think we really do have a significant concern in relation to the behaviour of banks.
The committee received first-hand accounts of what can at best be described as unprofessional conduct and at worst criminal behaviour worthy of serious investigation by Commonwealth authorities. And this was particularly with reference to the takeover of Bankwest.
He is an insolvency lawyer based in Birmingham, and he highlighted recently his concerns about the way in which GRG have behaved. But he also highlighted the fact that the whole insolvency business were also complicit in what is, in my view, an abuse of small businesses. He basically made this point. We in the insolvency industry have been complicit, collaborative and completely failed in what our role should be. Almost everyone in our industry have been effectively bought off by the banks. Accountants, IPs, insolvency practitioners, lawyers, surveyors, everyone. We have been bought by the banks.
Did you get any legal advice on your position on these receiverships?
Yes.
Is the legal advice available to the committee?
It's be subject to legal privilege.
Is there something in the legal advice that's a problem to provide the committee?
There's nothing within them that would be a problem.
Well, can I ask you to provide the legal advice documents to the committee?
Could I ask take that on notice?
Of course.
Yep.
Of course.
Yep.
I'm very pleased that the regulatory authorities are taking a look at the Tomlinson report.
The report was published on the 22nd of October. On the 23rd of October, it was given to the FCA, and I believe within days the FCA announced that they're going to have an investigation.
Huge concerns about Bankwest when the Commonwealth Bank took over Bankwest. Lots of arguments saying that Bankwest had a clawback system. It was in their interest to impair loans so that HBOS, Halifax Bank of Scotland, that fell over in the UK, would have to reimburse basically the Commonwealth Bank for the price they paid for Bankwest, whereas Commonwealth Bank and Bankwest said this is not the case. I suggest that ASIC look through the whole transactions and see that the corporations law has been abided to by all the way through that transaction.
ASIC has not received any evidence to suggest some sort of systemic misconduct by Bankwest in relation to these matters.
But the point is this: if they want to pursue that through the courts, which they have the right to do, they don't have any money. We all know what it costs to go to court. How can these people ever seek any justice without any money under the system? I mean, is ASIC prepared to look at these situations if I bring them to your attention?